Okay, well, it's 12:32 on the 31st of October 2022. Good afternoon. Thank you for logging on for our Law with Lunch talk. And we're going to be talking about time limits and extension of time in the employment tribunal. So Bharat and I chose this topic because it's an issue that has to be considered in every employment tribunal case, whether it ultimately becomes a disputed issue or not. And so Bharat and I are going to deal with the calculations to be done, continuing acts or conduct over time, the impact of early conciliation, the two different tests for extension of time, reasonable practicability and the just and equitable extension. We're going to look at general principles and a couple of recent cases and then finish off on practical tips. We've got an hour for this session. So we hope that once we've finished our talk, there will be opportunity for questions. I think there is a question and answer box at the bottom of your screens. So if you want to ask a question, you can pop it in there and we'll come back to those at the end of the talk. So firstly, this is the reason we chose this topic. It's the jurisdictional nature of the time limits. The most commonly referred to statutory provisions are unfair dismissal and Equality Act claims, and so those are set out on the slides. Different tests, but they are mandatory provisions, so the tribunal shall not consider, proceedings may not be brought. And of course, even if this issue isn't raised by the parties, the tribunal has to satisfy itself that it has jurisdiction to hear the claims. So we've referred there to the Radakovits and Abbey National PLC case, Court of Appeal case. In that case, the unfair dismissal claim was a day late. There was a PH listed to consider jurisdiction and the respondent conceded that the claimant's claim was in time. Acting on that basis, the tribunal set case management directions for a final hearing. The tribunal didn't give any declaration or make any judgment as to the time limit issue because of the concession. 2 years down the line, at the final hearing, of its own motion, the tribunal decided that the claim was out of time and that there was no jurisdiction to hear it. So on appeal to the EAT, it was held that the tribunal was entitled to examine the issue of its own initiative. Jurisdiction can't be conferred by agreement or waiver, and in an appropriate case, a tribunal will be obliged to raise jurisdiction even if the employer doesn't raise it. So tribunals don't have to consider jurisdictional issues fully in every case, and it was said they are not bloodhounds who have to sniff out potential grounds on which jurisdiction can be refused. So if on the face of it, it appears the tribunal has jurisdiction or that there is a satisfactory explanation for extending the time limits, then the tribunal can properly proceed on that basis. But where there has been an adjudication by the tribunal at a preliminary hearing, it's not for the tribunal at the substantive hearing to make a further judgment or reopen that issue.
When considering time limits, the Schedule 1 of the Employment Tribunal Rules of Procedure have paragraph 4 sets out the following. They are fairly, they're in simple language as opposed to not being overly complicated, but it's still worthwhile coming back to them as and when a time limit issue comes up, and make sure you've got the right calculation. Where something needs to be done by a particular day, it's on the it needs to be done on at midnight on that day, and it's for that party claiming to have carried out compliance of that rule or time limit to prove that they have done. If an act must be done within a certain number of days off or from an event, then the calculation is done from the next day onwards. So that date from which an event needs to be done by doesn't count. And so we've got here the 1st of October must present a response within 28 days. The last day for presentation would be the 29th of October as opposed to the 28th the date starting to count from the 2nd of October. And conversely, if in the opposite, if something needs to be done before or after an event, then we count backwards. So we have, if something needs to be done 7 days before a hearing, which is on the 8th of October, then whatever needs doing needs to have been done by the 1st of October. So that's 7 days, what would be 7 clear days, really, between the date on which compliance must be done and the date from which it needs to be counted from. Where we've got a document from a tribunal, the date the document is endorsed, or the document that the date it was sent, is regarded as the date it was created and from which time limit should be considered. If a date ends on or a time period ends on a day other than a working day, so Saturday, Sunday, the weekend, bank holidays, Christmas Day, Good Friday, then the requirement would be for the next working day. So like when we had the Queen's funeral, which was an unannounced bank holiday, as it were, any time limits which were due on that day would have had until the next working day to have been completed by. And then also when there's reference to a month, that is a calendar month, as opposed to say 28 days or 30 days or 31 days. It's 1 month on from January to February to March onwards.
Okay, so now I'm going to look at conduct extending over time, but just before I do, a few key points. So where the Act complained of is the refusal by the employers to redress a grievance, time runs from the date on which the decision was made and not the date when it was communicated to the claimant. And that was dealt with in the case of Verdi and Commissioner of the Police of the Metropolis, 2007 in the EAT. Where a claim arises out of the dismissal of the employee, the operative date from which time begins to run is not the date when any notice of dismissal was given, but the date when, by reason of that notice, the employment was terminated. And that's been dealt with in a number of cases in relation to race discrimination, sex discrimination, disability discrimination. And where a discrimination claim is based on a failure to select or promote, the date is to be determined by asking whether a cause of action has crystallised, rather than by focusing on whether the claimant felt that he'd been discriminated against. So if the cause of action is not complete, there would be no point in bringing proceedings. So looking at conduct extending over time, sometimes referred to as a continuing act, set out the relevant statutory provisions there. So section 1233A of the Equality Act, conduct extending over a period is to be treated as done at the end of the period. And the leading case of Hendricks and Metropolitan Police Commissioner from 2002, Court of Appeal, the applicant has to prove the incidents are linked to each other, there's evidence of an ongoing situation or continuing state of affairs, and the question is whether an act is extending over a period as distinct from a series of unconnected or isolated specific acts. And for those, time would begin to run from the date when each specific act was committed. So, for example, in the House of Lords case, Barclays Bank and Kapoor, 1991, the critical distinction was between the one-off decision, which had continuing consequences, and a continuing act or continuing state of affairs. So with the former, that would be conduct extending over time. For the latter, time would run from the end of the period in question. And two common detriments relied upon in the discrimination and whistleblowing claims, dismissal and demotion, are examples of the former, so one-off acts where time runs from the date of the decision. And another common example of a one-off act would be, with continuing consequences, is the decision to deny a promotion. And that was dealt with in the Court of Appeal case of Sugrin and Haringey Health Authority.
In regards to early conciliation, this is a compulsory requirement now since May 2014. So not only does a prospective claimant, have to bring their claim within 3 months for the majority of claims, 6 months for redundancy, from which the cause of action arises, they also have to enter into early conciliation with ACAS. And so I've just got some dates there which to help explain this. If, for example, a claimant was unfairly dismissed today, the effective date of termination being today, they would have 3 months less 1 day to bring their claims. So that would be the 30th of January 2023. But we also need to fit in the ACAS early conciliation period in that. And so day A is what's referred to when the claimant notifies ACAS. And then we have date B is when ACAS issue their early conciliation certificate. If there's over 1 month to limitation and the claimant notifies ACAS, then the days in between, day A and day B, are added on to the final period and for limitations. So, for example, if we have, with these dates, the 31st of October, day A is, say, the 8th of November, and day B is the 28th of November, those 20 days in which the case was in early conciliation, they are added on to the final period for limitation. So rather than having the 30th of January 2023 being the time limit, that would then extend to the 19th of February 2023. If, however, there's less than 1 month to limitation when the claimant, a prospective claimant, notifies ACAS, day A, then the claimant has 1 month from the day that they receive the certificate, so day B. So if, for example, we have the claimant notifying ACAS day A on the 15th of January 2023, and ACAS respond on the 28th of January 2023, the claimant would then have a further month to the 28th of February 2023 in which to bring their claim. There has been a recent case of Clark and others against Sainsbury's Supermarkets Limited and Lloyd's Pharmacy Limited, which touches on early conciliation certificates and early conciliation numbers and the issues pertaining to that when we have multiple claimants with multiple early conciliation certificates or not, and then a claim form. Here, the Employment Appeal Tribunal set out and decided that the Employment Tribunal erred in law in rejecting the claims of prospective claimants whose names did not appear on an early conciliation certificate, the number of which was quoted on the claim form in these multiple claims. It was sufficient that the claim form contained for each respondent an early conciliation number of an early conciliation certificate on which the name of one of the prospective claimants making the joint claim appeared. There are certain requirements as to what a claim form requires, and where there are multiple claimants, they can submit claims on the same claim form, whilst only providing and setting out an EC number, early conciliation number.
Okay, so now going to look at reasonable practicability. So we saw at the beginning that this is the test for extension of time for unfair dismissal, but it also applies to most Employment Rights Act claims under the Employment Rights Act, breach of contract, working time regs, TULCRA and TUPE. And to state the obvious, it's much harder for a claimant to satisfy this test than to satisfy the just and equitable extension.
The first question that the tribunal needs to ask itself is to why the time limit was missed, and the burden is on the employee, the individual bringing the claim, to show the reasons why it was not reasonably practicable to meet the limitation period. We have the case of Consignia and PLC and Sealy. In those circumstances, the claimant, the time limit was due to expire on the 8th of October 2000. The claimant sent their IT1, as it was then, the ET1, on the 6th of October 2000, on the understanding more on the understanding as opposed to an assumption that it would arrive on the 7th of October 2000. And so in those circumstances, it was only due to a procedural and an issue outside of the claimant's control, being delays in the post. When the claim form arrived at the tribunal on the 10th of October, the claim was therefore 2 days out of time. In those circumstances, the tribunal thought it was reasonably practicable, and it was appropriate to, it was not reasonably practicable for the claimant to meet the limitation period for matters outside of their control. Typically, there's many different reasons that claimants will seek to rely on when stating why there was a delay, and it's for the tribunal then to assess them all and make a factual determination as to which matter or matters advanced were an operative reason for the lateness. And sorry, yes.
So Bharat and I are now going to look at 10 of the most commonly advanced reasons that it was not reasonably practicable to bring the claim in time. So on my slide here, I've got the first 5 of those reasons. Probably one of the most common ones is ignorance or mistake on part of the claimant. And you see, we caveated that to say, except for faulty professional advice, which we've dealt with below. But the question is always whether the litigant's mistake or ignorance was reasonable. And the leading case on that is the Walls Meat case, where Lord Justice Brandon stated the impediment to a timeous claim may be mental, namely the state of mind of the complainant in the form of ignorance of or mistaken belief with regard to essential matters. Such states of mind can, however, only be regarded as impediments, making it not reasonably practicable to present a complaint within the period of 3 months if the ignorance on the one hand or the mistaken belief on the other is itself reasonable. And so it's an objective test with increasing coverage of employment rights and litigation in the media, with the ease of searching for information online, Google, another search engine. The case of justifiable ignorance will probably be fewer and fewer, but one can see examples of individuals such as those who are illiterate, those who don't speak English, those who have a relevant disability, or at the more extreme end, those who've been isolated from the usual sources of information. So, for example, victims of human trafficking. They may even now be reasonably ignorant of their rights. And then the second reason we've referred to is faulty professional advice, known as the dead man principle. And so where the claimant sought advice before the expiry of the time limit, where the failure to lodge in time is because of that faulty advice, then the general rule is that this escape clause will not be available. That might on its face seem harsh, but the position has been settled, reaffirmed. The Court of Appeal in Marks and Spencer's and Williams Ryan 2005 did a careful review of the criticisms of the principle and held that it was still valid. An interesting practical issue on that Court of Appeal case of Riley and Tesco stores from 1980 concluded that a tribunal should consider whether an advisor, and in that case it was a Citizens Advice Bureau advisor, against whom the allegation of fault is made, whether they should be permitted to put their side of the case at the tribunal hearing. And it was said that it would ordinarily be unjust for a tribunal to make an adverse finding against such an advisor without giving him an opportunity to answer what was said in his absence, or although that was said not to be an invariable rule in every case. So the third reason that we've looked at is ill health or disability, which could be physical or mental ill health. Clear factual findings will need to be made about the nature of the illness. The issue of fluctuation has to be dealt with. And in the Schultz case, which we've referred to there, it was said it wasn't right to give a period of disabling illness similar weight, irrespective of the part of the limitation period in which it fell. So overall, the focus should be upon the later stages of the 3 months or the applicable time period, reflecting the reality that in most cases, that is when litigants focus their minds on lodging a claim. And in that Schultz case, the claimant had been dismissed for long-term absence due to depression. He was physically capable of giving instructions to his solicitor for the first 7 weeks of the 3-month period, but was too ill to do so for the last 6 weeks. And so the Court of Appeal overturned the decision of the tribunal and the AT that it had been reasonably practicable to present the claim in time. Fourthly, problems with the post. Bharat's already referred to the Consignia and Seeley case. So 3 propositions really. The not reasonably practicable escape clause is available where a claimant posts their claim on a date which in the ordinary event would result in it being made in time. And if it arrives late or not at all due to an unforeseen circumstance, if that condition is satisfied, the escape clause remains open, even if the claimant's waited to the last minute. And the question of whether the condition is satisfied is a question of fact. In the Consignia case, Court of Appeal concluded the reasonable objective expectation was that the claim form would arrive on the 2nd day after it was posted first class, because that was that deemed date was outside the primary time limit. Then the escape clause didn't apply. And then finally, technological issues. The Consignia principles will apply, although that was dealing with the postal service. It's capable of applying to claims lodged via the online portal. So the same principles where a claimant does an act which in the ordinary event would result in the complaint being made on time on the online portal, but was prevented from having its normal and expected result by an unforeseen circumstance. Then if the condition is satisfied, it doesn't matter if the claimant waited until the last minute. And again, it's a question of fact to be determined on the evidence.
I am mindful of time, so I'm just going to whiz through these other possible reasons where there is an internal appeal there, and a claimant waits the outcome of that internal appeal before issuing a claim and thereby misses a statutory deadline. They will face an uphill struggle to convince the tribunal that they couldn't have brought their claim earlier and lodged it in time. In the case of Palmer and Southend-on-Sea Borough Council, the tribunal and the court considered at that point the appropriate thing for the claimants to do when they knew that they had a claim to bring and they knew that there were time limits in relation to that. They should have issued their claim and sought an adjournment for that internal process and appeals process to be satisfied, to be concluded first before proceeding on with the claim. And that links in also to the next point as to whether there are other pending legal proceedings where if an individual delays making a claim for an unfair dismissal, for example, until the conclusion of the criminal process, they will not be able to say it was not reasonably practicable to present it in time. Again, if they are aware of their claims, they know about their claims, they know about the time limits, it's for them to bring their claim first and then, if appropriate, seek an adjournment or to seek appropriate directions for the case to then be dealt with at the conclusion of those other legal proceedings. that was the case of Wars Meat Company and Khan, where in that instance the claimant had other legal proceedings ongoing, and he thought that the legal or his unfair dismissal claim would be dealt with that other claim. It wasn't going to be. As soon as he found that out, he took steps to deal with that. But I'll discuss this later as to what a claimant should do when they find out when they have a claim. Where a claimant is in negotiations with an employer and trying to avoid litigation, that isn't necessarily a reason why it wasn't reasonably practicable to bring the claim in time. Again, where a claimant knew of all the facts necessary to make a complaint in time, and in this case, the claimant knew that they were offered a other alternative employment, which was subsequently withdrawn. Those steps and those matters don't necessarily stop a claimant from bringing a claim. They are to bring a claim and take appropriate action following that. Conversely, where we have a discovery of new facts, and we have the case of Machine Tool Industry Research Association and Simpson, where the determination, it was said, that of reasonably practicability involves a study of the claimant's subjective state of mind. And Lord Justice Purchase set out three things which are neatly summarized in the final point, where that the acquisition of the knowledge is crucial to the decision to bring the claim in any event. If a claimant didn't know about any claims that they could bring, and then found out new facts which allowed them to bring a claim, that may be a reason as to why limitation should be extended, and it was not reasonably practicable for them to bring their claim any earlier. Finally, we have commercial concerns in Birmingham Optical Group and Johnson, where if for example, in this case, a employment tribunal claim would have or had a detrimental impact on commercial negotiations which are ongoing alongside the potential tribunal claim, that isn't a reason to say it was not reasonably practicable to bring a claim any earlier, and especially where the claimant, as the court found, was a man of commercial sophistication. Bryony's now got a case where we have a more recent case dealing with reasonable practicability.
Yes, so in Signet Behavioural Health Limited and Britain, in the Employment Appeal Tribunal earlier this year, Mr. Britton was a physio, dismissed during his probationary period and subjected to a fitness to practice investigation. He sought to bring a Section 103A protected disclosure automatic unfair dismissal claim. He commenced ACAS early conciliation in good time, but sent the claim form in 62 days late. So at the hearing in the ET, it was argued it was not reasonably practicable to bring the claim in time. It was said that the claimant didn't know the time limits for an unfair dismissal claim. He assumed it was akin to NHS time limits. He'd asked an ACAS advisor about time limits. He'd been told that he couldn't comment on a specific case, but to submit the sooner the better. He didn't carry out any inquiries about the unfair dismissal time limits, and relied on his assumptions, his depression, and his dyslexia, saying that he was unable to easily review information on a web page. And he also relied on the extensive time that it was taking to deal with the fitness to practice issue. So at first instance, the ET found in the claimant's favour, time should be extended. It accepted the claimant's reasons entirely, and found that the delay of 62 days was reasonable considering those factors. In the AT, it was held that decision was perverse. There's a good run through of all the authorities on perversity appeals in this case, as well as reasonable practicability. So it's worth having a read of. The AT noted that the claimant had corresponded with the regulator during the time period for the ET claim, and had in fact prepared 537 pages of correspondence with the regulator. It was found he was aware of the time limit but didn't take any action to find out what it was. And it was said that a person who's considering bringing a claim for unfair dismissal is expected to appraise themselves of the time limits that apply. It's their responsibility to do so. And so in his case, even if the pandemic meant it was not easy to speak to somebody, the claimant could have been able to type a short sentence into a search engine, or could have asked an acquaintance by email to search for that information. And so, although the Employment Tribunal had directed itself correctly as to the law to be applied, it had arrived at the wrong decision on the facts. So that's reasonable practicability, and Barrett's now going to deal with further reasonable period, the second part of the test.
And so once a claimant is known or knows about a claim that they could bring, they are expected to make their application as quickly as possible once that matter that prevents them making their claim has been removed, and the length of time will be dependent on the circumstances. As indicated in the Wars-Meat case, here the period of delay following the claimant's knowledge of finding out about the fact that the unfair dismissal claim would not be dealing with the unfair dismissal claim, he then brought his claim within a further 4 weeks. This was held to be reasonable in the circumstances because the period straddled the 2-week Christmas break, and the claimant provided evidence to say that he had experienced difficulty in finding a solicitor to deal with the matter. We've also got the case of James W. Cook and Co. and Tipper. Here, in this instance, the Court of Appeal considered that a reasonable period in the circumstances was 2 weeks from the closure of the shipyard. So where we had the employees, they were told they were being dismissed for redundancy. They were under the impression and were told that they would be re-employed. They didn't make any claims for unfair dismissal on that basis. Time limit expired, the company was shut down. Some employees made a claim within a couple of days from the company shutting down. Some took up to a month. The Court of Appeal found that it was 2 weeks in these circumstances that would have been a reasonable period within which to bring their claim. Moving on, Bryony is going to now talk about the just and equitable test.
Yes, so the headline really is it's a wide discretion. It's much easier for the claimant to satisfy this test than not reasonably practicable formula. The burden is on the claimant to persuade the tribunal. It was said in the Robertson and Bexley Community Centre case that the exercise of the discretion is the exception rather than the rule. There is no presumption of extension. Rather, it was said in Miller and Ministry of Justice by Mr. Justice Lang in the Employment Appeal Tribunal 2016 that the presumption is that time will not be extended, but that may be displaced evidence. And in Radhakrishnan and Pizza Express restaurants from 2016, His Honour Judge Peter Clark identified a proposition which was that the burden of persuasion is such that if the claimant advances no case to support an extension of time, plainly he is not entitled to one. So it's an important thing for the claimant to deal with, to advance evidence on. And just finally, it's always necessary, just as in reasonable practicability, that when exercising the discretion, the cause of the claimant's failure to bring the claim in time has to be identified.
When considering whether to grant a just and equitable extension, the test is akin to, and the matters to consider, Section 33 of the Limitation Act. So the court is to consider the prejudice to the parties as a result of either granting or refusing the extension. And those include A to E there, so the length and reasons for the delay, the extent to which cogency of the evidence is likely to be affected by the delay, the extent to which a party is sued has cooperated with any request for information, and the promptness with which the claimant acted once he or she knew of the facts giving rise to the cause of the action, and also the steps taken by the claimant to obtain professional advice once they knew the possibility of bringing an action. Whilst we do have a list there where on consideration of all of them, it will be considered to be just a tribunal will be able to consider whether something is just and equitable. There is no legal requirement for the tribunal to go through that list, and provided as set out by Lord Justice Gibson in the case of Southwark London Borough and Afolabi, so long as no significant factor has been left out of account by the employment tribunal in exercising its discretion, then a tribunal will have been seen to have considered what is just and equitable.
So just looking at internal processes, so grievance or disciplinary appeal processes, for example, this may justify the grant of an extension of time, but it's one factor that must be weighed in the balance along with others that might be present. So in the Robinson and Post Office case, the claimant was pursuing an internal disciplinary appeal, but because he knew of the time limit for bringing a race discrimination claim, and because he refused to take his union's advice to lodge the application in time, it wasn't just and equitable to extend time there. And in the Appellant Gabriel's case, the Court of Appeal rejected the suggestion that there is a general principle that extension should be granted where the delay is caused by the internal grievance or appeal procedure, unless the employers could show some particular prejudice. And just a note on prejudice, in the case of Abatawi Bro Morgan University Local Health Board in Morgan from 2018, Lord Justice Leggett referred to the question of whether the delay had prejudiced the respondent as a factor, which would almost always be relevant to the exercise of the just and equitable discretion. But Mr. Justice Lang drew attention to this in Miller and Ministry of Justice, Employment Appeal Tribunal 2016. It was said that prejudice is an important but not determinative factor. So one of the matters to take into account, but not necessarily the be-all and end-all.
We've got this recent case of Kumari and Greater Manchester Mental Health NHS Foundation Trust, which considered the just and equitable test and what factors a tribunal should take into account when considering what is just and equitable. This case was heard in April, and the decision came out, I believe it was the end of August 2022. And it was one of our colleagues, Amy Rumbles. She was in the EAT in this case. I believe she's got an article coming out in that, so please do look out for that as well on the website. In this case, the claimant had presented a complaint of direct race discrimination and or harassment, that they were out of time. They sought to bring a further standalone Equality Act, which would have been out of time as well. At the preliminary hearing, the Employment Tribunal refused to extend time, and when considering what was just and equitable and what was appealed against was the fact that the tribunal weighed into the balance the merits of the claimant's claims. The claimant's representative, I believe they were unrepresented at the initial PH, but then at the appeal hearing was represented. they set out various points as to why they thought that the balance of the merits of the claimant's claim should not be taken into account, but the appeals tribunal rather, dismissed the appeal. As Bryony and I have already set out and neatly summarised at paragraph 55 of that judgment, the employment tribunal have a wide discretion, and it's for them, and there's no definitive list or exhaustive list as to what they do or do not consider and as relevant or irrelevant when making their determination as to whether it's just and equitable. But when it comes to considering the merits of the claim, at paragraph 64, if the claimant has been provided with the opportunity to provide the appropriate evidence and enough evidence on key features of the case, whilst appreciating it isn't a final hearing, and such that the tribunal can perhaps consider readily apparent features that are either weaknesses or obstacles for the claimant, and the claimant has addressed them on that, then the tribunal could bring that into the consideration as to whether it is just and equitable to bring it to extend limitation. But if the tribunal is not in a position to consider the merits of the case, then they should not be weighing that into account. If, however, the tribunal do have appropriate information and they do take it into account, quite interestingly, the appeals tribunal has set out that the appellate court would not interfere with that approach to assessing the merits or the weight attached to them, unless it is in the legal sense perverse.
Okay. Then we thought it might be quite helpful to deal with some practical tips, which no doubt many, if not all of you, already do. But if acting for the respondent, obviously take the point and set out the respondent's case. If you can be specific about the dates and how far you say each claim is out of time, then that's really helpful to get that down at the outset, particularly if an employment judge is considering on the papers whether to list a preliminary hearing on the matter. On behalf of the claimant, I think it's helpful to plead the extension of time, even if it's in the alternative to the primary case. So if you're saying, for example, there is conduct extending over time, and therefore time should start at the end of the period, then you can plead the alternative position that there should be an extension of time in the ET1. If you're asking for a preliminary hearing on time limits, then there's no harm in doing that in the ET3. And also to address that in the covering email or the letter to the tribunal. In terms of the preliminary hearing itself, it's always helpful if you have a witness statement from the claimant in advance so that you know what the reasons are beforehand. Otherwise, you're in the position where you have to wait till you get to the tribunal hearing, hear the claimant's oral evidence, deal with cross-examination on the hoof, as it were, and then be armed with all of the relevant case law, some of which we've gone through today. So getting a witness statement from the claimant does assist. It also helps to focus the claimant's mind on what exactly the reasons are, rather than turning up and perhaps doing their best on the spot without having properly considered why the claim was submitted late. And even if there's not going to be a preliminary hearing on time limits, then it should be dealt with in the list of issues before the final hearing. That way it can be dealt with as a preliminary issue if appropriate at the final hearing, or at least it's at the forefront of the tribunal's mind when the hearing is commenced. And Bharat's going to say a bit more on preliminary hearings.
finally, from me, it is a consideration to make as to whether there should be a preliminary hearing or not. If there is conduct extended over a period of time, and it's fact sensitive, and the tribunal will need to make a careful assessment of the full sequence of events before making a finding of or in relation to time, that probably isn't a case in which a preliminary hearing would be useful, notwithstanding the fact that the tribunal is unlikely to have all of the information to deal with that. And that's at that point, time is likely to be dealt with and more appropriately dealt with at the final hearing. There are perhaps exceptions, and one is set out there. If, for example, a claimant has relied on two detriments, separated by a passage of years, and there's no obvious connection between the acts, a tribunal is likely to be able to make sufficient inquiries and allow the parties to make appropriate submissions on the point of time. And that probably is a circumstance where a preliminary hearing would be useful for both parties and the tribunal to consider whether time is still an issue or not. Justice Ellenbogen has set out 13 principles on when considering time periods and whether a preliminary hearing should be considered or not. That's at paragraph 50 of that judgment. It is unreported, but with that reference, it comes up on the gov.uk website. And that is definitely something that I would recommend to review rather than continuing into your lunchtime. That brings, and me discussing it now, that will bring the presentation to an end. So thank you all for attending. I do have, if you don't mind, Bryony, I'll be question master. We do have one question in the Q&A box already.
I just can't see them because I'm screen sharing. So perhaps if I stop sharing, then I'll be able to have a look. So
sure, I can read it out as well.
Yeah. Yeah. Okay. I can see them now. Yeah.
Sure, no problem.
Okay. So, oh yes, please. Can you send the slides out? Yes, I'm sure we can do that. We'll have a word with our marketing team after the event. And from a practical point of view, other than jurisdictional time limits, is it worth aggressively policing directed time limits? So because it's jurisdictional, I think it's always worth taking the point. You've got the potential of knocking out all of the claim on that one ground. So if you can get a preliminary hearing on the points, fantastic. As we said in our practical tips, plead it, set out in detail what the respondent's case is on it, say what the dates are, how far out of time it is, and see if you can get it knocked out. I suppose aggressively. I think it's just worth setting out what the position is and asking for a preliminary hearing and seeing where you get to. It's always worth taking the point. I don't know if you've got anything to add, Barrett.
No, not particularly. If there are directions as to providing various evidence, it's probably worth taking a holistic view. Whilst it is worth taking the point, it's probably not always worth taking every point every time.
Yeah,
I would understand. So it just it would be sensible for respondents, from a respondent's position, to take appropriate points. Again, it probably doesn't look best on respondents if they take points that the tribunal doesn't think that is worth it or appropriate taking.
Yeah, and that's true. And you'll soon know if the employment judge doesn't like it that you've raised a particular point, I'm sure, especially if you get to the preliminary hearing on time points and that they've read the papers. So I think that's a fair point. I think that those two are only questions, weren't they? Barrett, I can't see any others.
Yes, so far, unless anybody wants to get anything in now. I appreciate we're 50 minutes into a 1 hour talk. You may have other things to do in your lunchtime and may want to get off.
But if anything occurs to anybody after the seminar today, they can always drop either me or Barrett a line, and we'll be happy to answer as best we can any questions that you have arising out of the talk.
Definitely. as Bryony indicated as well, this presentation has been recorded. I believe it's going up on our YouTube channel. I didn't realise Chambers had a YouTube channel, so
I think so. Yep.
it's going up there, and like Bryony said, we'll make sure that the slides are sent out to everyone and to attendees.
Yeah. So thanks all for your time, and enjoy the rest of your lunch.
Thank you. Bye bye.
Bye bye.